I work at New York Public Library just up the street, and it's kind of an honor to be invited to this conference, and we'll get into why I'm really excited to be here in just a second. So first, let's go walk through a roadmap of where we're going to go for the next 30 to 45 minutes or so, and see how we're going to end up. So first, I want to talk about the importance of copyright to libraries. Why libraries and archives are so interested in copyright law, and how it impacts how we do our work. And we'll talk a little bit of a copyright refresher, because I am a copyright nerd, but not everyone is a copyright nerd. So that means sometimes I need to kind of explain what I mean. We'll also talk about some rights metadata at NYPL and some of the work that we've been doing, the work that Chris highlighted just a second ago, and how that work impacts our service. We'll talk about how we've converted some of the rights metadata that we've been working on into action, and how we've really used our rights metadata for our benefit. And then we'll get into the future of rights metadata, or at least where I think the future of rights metadata is at cultural heritage institutions. And we'll have some time for questions. So first, why rights metadata? So why are we spending an hour or 45 minutes talking about rights metadata at a symposium like this? Why do cultural heritage institutions care so much about recording and tracking rights metadata? Well, for libraries like mine, it's all about the numbers. So a few years ago, researchers accessed 1.6 million items in our physical collections. That's an increase over years past, and is part of the trend of an increased usage of physical items. But over that same time period, we had over 127 million views of digital objects on our online platforms. That's an 80 times difference. And that number continues to grow. That separation continues to grow exponentially as we move forward. So for 100 years, we've been focusing our energy on physical objects and on the storage of those objects, but we are transitioning into focusing on digital assets. That's why participating in this conference is so exciting for us. Digital access to our collections is critically important to how we serve our patrons and how we meet our users where they are. So this shift from patrons coming to libraries meeting patrons where they are has some important implications for libraries and cultural heritage institutions. First, it means that libraries are digitizing their collections, whether that means they're doing it in-house, or relying on partners, or relying on vendors to help digitize that content. They're digitizing it so that they can serve it online and hopefully on the web, but at a minimum, at least on site. So we're digitizing our content and making it available on our site, but we're also expanding access to that material. We're pushing the boundaries of where that material can be served beyond the four corners of our websites. So we're sharing digital content with third parties to enhance access and reach our users where they are. So we're relying on entities like the Digital Public Library of America and HathiTrust. We're pushing our content to them so that users can find our content in many different places. So DPLA, for those who don't know, is a metadata aggregator that collects metadata about cultural heritage collections and objects in those collections nationwide, so that users can use a single platform to research and find those collections, to make them discoverable. HathiTrust, on the other hand, is a digital repository of books scanned from the collections of research libraries. So these are books scanned, for the most part, by Google with Google Book partnerships, and are physically stored in the digital repositories of HathiTrust. But all this digitization and sharing brings us to the third implication for institutions like mine, and that's copyright liability. Copyright liability is nothing to laugh at. Statutory damages in this case are $150,000 per work infringed. That means if you digitize 10 items and that's an infringing action, and you hit the maximum statutory damages, we're at $1.5 million in damages. NYPL doesn't digitize 10 items at a time. We digitize thousands of items at a time. So if you digitize 1,000 items and you get it wrong, we're at $150 million of potential statutory damages. Those numbers get really scary really quickly when we're talking about institutions that digitize thousands of items per month. So because the stakes are so high, libraries like mine need to do the research necessary to understand and accept the risk of using content created by others. And this is not kind of an aspirational goal. These lawsuits are actually happening. Unfortunately, there's been a few copyright lawsuits against libraries in recent years. The good news is that the libraries, for the most part, have been successful at defending their activities. Recently, the Supreme Court turned down a request by the Authors Guild to overturn a decision that held that Google's digitization of in-copyright books for the purposes of search and for the purposes of snippet display were held lawful. That's good news for us because we've digitized content. Although NYPL wasn't an in-copyright partner, we only digitized public domain material. But in any case, it demonstrates that these lawsuits aren't just some figurative potential threat. These are actual threats. The other reason why rights metadata is also important to libraries is because of the sheer numbers of assets we're talking about. So you heard just a second ago that 90,000 is a hard kind of asset database to deal with. Libraries are developing rights metadata so they can get a handle on the bigger numbers. So NYPL has roughly 1.8 million digital assets in our repository at this point. DPLA has metadata on over 13 million assets. HathiTrust has over 14 million volumes in its collections. Those are a lot of assets, and managing data about those assets is not always easy. So given these legal issues, combined with the ambition of libraries and the sheer volume of the assets we're dealing with, rights metadata is critically important. Rights metadata can help shape and implement risk profiles of an institution, can protect the institution from bad choices or dumb choices, but can also help rights holders kind of connect with libraries and archives and make sure that the assets are used in the right ways. So what do I mean by rights? How many of you have dealt with copyright issues before or have some knowledge of it? Okay, good. That's better than most audiences I talk to now, so that's good. It's interesting to me because copyright is everywhere. Unlike much of federal copyright or federal law, copyright law is the kind of core law that impacts us all every day. We create works that are automatically protected by copyright. The notes that you're taking are protected by copyright law automatically, and we use copyrighted works every day. So all of those SNL clips are all protected by copyright, and we use those works, we access those works, and therefore we engage in the copyright system. But despite the pervasiveness of copyright in our daily lives, it's not always well understood. So I'm going to spend a couple of minutes walking through some basic fundamentals to kind of lay a groundwork for to demonstrate what we collect for rights metadata and how we use that data. So copyright law's foundation comes from the Constitution, which gave Congress the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their writings and discoveries. So our founders decided that copyright was important enough to include in the Constitution and grant Congress the power to create those laws. So what does copyright law protect? It protects original works of authorship fixed in a tangible medium of expression. It's kind of a wonky phrase, but what it really means is that copyright protects things like books and fine art and music and film. But ultimately, format doesn't matter. All that matters is that it's original expression and that it's fixed in some way. So once you have a work that's protected by copyright law, you as a rights holder get a set of exclusive monopoly rights. And those are rights that the rights holder get when they own the copyright, and sometimes we refer to them as a bundle of rights. This bundle of rights is the right to do something and to prevent others from doing something. So for example, the rights of a rights holder include the rights to make reproductions, to create copies of their works, to create derivatives of those works. So the Hunger Games book turned into Hunger Games the film, and that's a derivative of the book. Rights holders also get the right to distribute copies, the exclusive right to distribute their copies, and to publicly perform and display. So every summer out in the back of the library, HBO comes and does a summer film series, which is great. The mad rush onto Bryant Park is always fun to watch, and I get to watch it from the balcony of the library, so it's kind of fun. But all of these exclusive rights are balanced against exceptions and limitations to these exclusive rights. So these exceptions and limitations permit users to lawfully use works without seeking permission of rights holders. One of the most important exceptions and limitations is fair use. Not only is it important for cultural heritage institutions to make material more available, it also is important for companies like Viacom, who make material based on the work of others, who use clips in their shows, etc. So fair use is critical to all of these activities, but it's only one of many exceptions and limitations. So how long does copyright last? These exceptions and limitations come in handy now that the duration of copyright protection is so long. Today, it's life of the author plus 70, but it wasn't always that way. At the beginning, in 1790, copyright protection lasted for 14 years. And that's it. 14 years with an option to renew for another 14. So 28 years after publication, the copyright expired. Today, it's life of the author plus 70, and these charts aren't exactly in proportion. The bottom two lines should be much longer, but that's the duration of copyright today. All right, so given all of this copyright background, let's talk about rights data at NYPL. So my story at NYPL begins with this date. NYPL had been digitizing material for over 10 years before my position at NYPL was created. We were primarily focused on digitizing book plates out of books that were published before 1923. In other words, very, very safe material. But it became apparent pretty quickly that having a digital library that ends at 1923 wasn't sufficient. It's not sufficient for our users, and it's not sufficient for us. We can't have a black hole in our cultural memory, our cultural history, that ends at 1923. So we needed to expand our digitization efforts and break through this barrier of 1923. So I'm the Associate Director of Copyright and Information Policy at NYPL. I was hired just over 5 years ago at this point. That's a long title. What does it actually mean? Well, there's about 45 of us who do what I do at libraries. Actually, one of them's in the room, so you've now got 2 of the 45 in this room. But I'm the only one who does what I do at a public library. So I am the copyright person at New York Public. That means I'm the copyright nerd. It means I'm a licensed attorney, but I don't work as an attorney on behalf of NYPL. Interestingly, it also means that I am not a librarian. So I didn't come to the library with a library degree. I came to the library with a copyright degree, with an understanding of the law in this field, and an interest to help NYPL make this content more available. So my job is first and foremost to expand access to our collections, both in person and online. I work with curators to increase access to our collections as broadly as possible. My second job is don't get sued and lose. All right, one more time. There you go. You have to have a cheesy graphic sound there. So don't get sued and lose, and do those things in that order. So my job is to expand access and push boundaries. And if I were in the council's office, my job would be the opposite. It would be don't get sued first and foremost, and then worry about access. And that's why my position is kind of an interesting position, and why when I started, there were only 20 of us doing what I do. We've doubled in numbers in the last 5 years. The other thing I've been doing a lot lately is finding myself engaged in copyright policy conversations in Washington, D.C., in Albany, and in other places, especially now that Congress has started a review of copyright law. A few years ago, I testified before Congress on behalf of NYPL on copyright issues on first sale. And it's been an interesting exercise to kind of expand the scope of this role from just rights metadata to also the policy work. So we accomplished the task of helping manage the institution's risk profile by gathering rights data about our items, analyzing it, and recording how we can use each of these assets. My initial task when I started was to develop and refine a system to track and record data about our digital assets. So when I started, we began looking for pre-built rights databases. We wanted kind of to make a shortcut, so we were looking for pre-built databases, and what we found surprised us. In an industry that cares a lot about standardized data and standardized schemas, we found a significant lack of consistency on rights metadata. For the most part, rights metadata is found in some kind of free text field, usually in some kind of Dublin core field, and really isn't valuable or useful or correct often. Diane actually spent some time highlighting in her talk about the horrors of unstructured data. Free text fields like this are the horror that we're dealing with. So knowing that there were no pre-built databases, we started looking to industry leaders to understand how they were tracking rights metadata. So California Digital had published a really good report about rights metadata and has tried to establish a rights metadata schema. The Getty Institute had developed a great paper about what data we should be tracking. And both of those things were really helpful for us to establish our own database. But there was no widespread adoption of either of those. And I should also note, as we move forward, we've used other people's work in this field and incorporated it into our own system. So Hadi Trust had built this wonderful way to categorize the copyright status of an item internally. They added reason codes. It was a great system, so we ended up incorporating a lot of that work in our own system. So as new local schemas were implemented, we've been using and borrowing those elements that we liked from other people, but ultimately there is no standardized system, at least in the library world, for rights metadata. And there's also no magic rights database that we can all use. So we had to build our own, and so that starts with gathering requirements. And I'll walk you through a few of the requirements that we had to give you a sense of why we are so invested in this. So the first requirement we had was that the system that we built had to record the provenance of an object. And by provenance, I really mean how NYPL acquired the object, especially if there are donor restrictions or whether we created the item. We want to know how this object came to NYPL. The second thing we also want to know is whether there are any contract restrictions or licenses on our use of that material. So as we work with rights holders to increase access to our collections, we want to record any licensing agreements that we come to. We also want to record any restrictions that we may have agreed to when we digitize something through a vendor or a database, et cetera. Any changes to the default rules of copyright law we want to record, and usually those things come in contract restrictions. We also wanted a way to store these documents with the rights records themselves. So instead of relying on a stick that's actually in my bag that has all of the contracts relevant to rights data at NYPL, we needed a way to upload those documents and store them next to the data about those objects. It would be a bad situation if we were able to record information about the contracts but not actually be able to see the contracts. That would be a bad deal for us. The third thing we needed was to record facts relevant to the copyright status of the object. So we want to record facts like publication status, place of publication, creation and publication dates, and any copyright notices that would be relevant to making a copyright status determination. Using that data, we also then want to make the copyright status determination when we can. Making sure we know what the copyright status of an item is really important to us understanding our risk profile at NYPL and how we can use assets. We also wanted to track other kinds of rights issues that may impact how we can use assets. So for example, we want to track whether there are trademark issues in an item or a film. We want to track rights of privacy, rights of publicity. And when we have releases that waive some of those issues, we need to identify who is in those images, who's in the asset, name them, and associate their name with those agreements, with those waivers or those permission agreements. And finally, based on all of the above, we need to track how we can actually use the assets. So we need a way to tell NYPL's digital systems how the asset can be used and whether that particular system can use it and how that system can use it. So all of this data has to be programmatically actionable. The data has got to be outputted using APIs that are standardized for NYPL systems so that all of our digital content platforms can tap into this resource and understand how those assets can be used. So based on those requirements, we built our own system. This is a Ruby on Rails system that sits on top of our digital repository. If you ask me any technical questions beyond what is Ruby on Rails, you're not going to get a good answer from me, but I'll relay that back to my developers. But this is the front page of our internal metadata management system. This system is used to track all sorts of metadata about our digital assets. We track descriptive metadata, rights metadata, technical metadata, administrative metadata, all different kinds of metadata in a single system. And just to give you a sense of the rights side of this database, here's a quick scan of the database that includes some made-up data that I had to include. Although we don't have time to talk through the form itself, there's space for all the information that we want to collect. Because you can collect a lot of information, we have a lot of fields. As you can see, it scrolls through and there's a lot of fields there. You'll see sections on how we acquired the object, any contractual restrictions or permissions, other rights issues that impact how we can use the asset, relevant information to help with the copyright status determination, like publication date and place of publication, the copyright status determination that we've made about that asset, and finally at the bottom, there's a section on how we can actually use that asset based on our institutional risk profile. So all of that data, especially the data at the bottom that describes how we can use assets, has to be programmatically actionable. That means no free text fields for that data, and for us that usually means checkboxes to say this use is approved, this use is not approved. The other requirement that we had for this system is that it has to be flexible enough so that when the institution changes its risk profile, when we have a different view about copyright law, or when copyright law changes, we've got to be able to make those use changes in the database without dislodging or disturbing the factual information underlying it. So we have to be able to track data in different kinds of fields so that if things change, we can go back and filter based on that data and make the appropriate changes. So as I said, we have a lot of assets in our repository, and although this form looks very imposing, we've been able to get through a significant amount of these records in a relatively quick amount of time. As I said, we have about 1.5, 1.8 million assets in the repository, and this chart represents our progress at adding copyright status determinations to our records. Since May of 2014, we've added copyright status determinations to about 640,000 captures. So in about 2 years, we've added rights data to about 640,000 captures. We've also been keeping up with all of the new digitization at NYPL, plus working through our backlog, and that's why you see the trend line going down. We have about 17% of the repository left to review, as well as keeping up with all of the new digitization at NYPL. So for us, this is a pretty exciting chart. It shows that although the system can be complicated and intimidating, it's actually creating progress. And so let me show you the team at NYPL working on this. This is my team working on researching, analyzing, entering rights information. There's me. There's someone named Kiowa Hammonds. He's the rights clearance coordinator at NYPL. And that's it. It's us. So although we're a very small team, you can tell that we've been able to keep up with the pace of digitization at NYPL, as well as chipping away at the backlog. So it's not an impossible thing. It's not impossible to start to track and record information about the assets in the repositories the cultural heritage institutions have. And one of the reasons why we're able to get through assets and get through our database so fast is that we've been able to rely on the structure, the metadata structures of the collection. That's why in a few slides ago in the burn down chart, you saw that it was very chunky. You would see very strong, very deep dips and then kind of plateaus for a little while. And that's when those big dips were when we were able to add rights metadata at the highest level of a collection. So when we have homogeneous collections, or at least homogeneous for rights purposes, we can set a single rights profile that can impact thousands of assets. So in other words, we can start at the top of this chart, set a rights profile, and have it cascade all the way down. Of course, we're not always so lucky. That's why you see a lot of plateaus on that chart. So we got a lot of heterogeneous collections where we need to do more refined analysis, where we need to work on the collection or the container level or even the item level. We can also work across hierarchies in situations where we've secured a license from the rights holder, but the rights holder work appears in multiple places in our collection. So for example, a photographer's photos who represent much of Broadway during a certain period of time may be located in hundreds of collections at NYPL. But if we've secured a license from that person, allowing NYPL to do certain things with those photos, make those photos available, we need to be able to tag all of those items across the entire repository. So that's working both horizontally and vertically has been a wonderful benefit to the system. Okay, so this data is powerful. It allows institutions like mine to fine-tune how we can make material available to our users in ways that maximizes that access while respecting the rights of rights holders. And one example of this is our public domain release. In January, NYPL released 187,000 high-resolution images of items that we believe to be in the public domain. Images like photos taken by Bernice Abbott, early photographs of algae, photos taken by the Farm Securities Administration, and maps. So many maps. Over 20,000 maps are included right now available for high-resolution download for free on our site. There's also things like Japanese scrolls that you wouldn't necessarily think of that are now available in high resolution, so you can actually see the whole scroll in fine detail. This wasn't the first big release of high-resolution public domain images by NYPL or other cultural heritage institutions. In fact, we were kind of latecomers to this. The Library of Congress has been doing this for a long time. But this release kind of took on a life of its own, and we got some nice press about the release. So by collecting the copyright status information in the rights database, we can also make high-resolution images of items we believe to be available or believe to be in the public domain to our users. When a user comes across an item that we believe to be in the public domain, they're able to get options to download the higher resolutions of those items. Another way we hope to use all of this data that we've been storing is to communicate rights information to our users. One of the #1 questions we get in the rights side of the house is questions from users about how we can reuse assets. So for example, let's say, can I reuse this asset? Is it in copyright? What's the copyright status? Can I facet searches based on the rights status in your database? And for the cultural heritage institutions, we're worried about how we communicate the answers to these questions responsibly. We don't want to be providing legal advice to our users, but we also want to help users make their own decisions. And today we're not doing such a great job at that. As an industry, we're not doing a really good job at that. Of the 12 million items or so in DPLA, contributing institutions have used more than 87,000 unique and different rights statements to describe the assets in their collections. So think as a user encountering 87,000 unique statements about the copyright status of your items, tricky to work with. This is a visualization of a small subset of that, and each of those boxes are independent and unique rights statements that others have used about the copyright status of their items. Another way to look at this is the number of words used to describe assets. So in DPLA, 25% of the words stored in the DPLA metadata system are devoted to rights statements, and just rights statements. That represents the largest amount of data in the database, and it's the next largest field, source field of words is the description field, which is down to 22%. So we spend more words on rights statements than we do on describing the actual assets. So DPLA, Creative Commons, and Europeana started to work through this problem a few years ago, and after consulting with cultural heritage users and the community, they developed a set of rights statements that are meant to be reusable and meant to kind of narrow this down. So 2 weeks ago at DPLA Fest in Washington, DC, this project was launched. You can find the less than 1 dozen statements on rightstatements.org. We've produced less than a dozen to help institutions clearly communicate copyright status to users in a responsible way. These statements are both human and machine readable. There are URIs associated with it, and those URIs are important because unfortunately there isn't some magical repository or database of public domain items or of copyright status. Instead, we've got to make the determinations ourselves. So the hope is after a few years of adoption, the URIs and APIs institutions use in their metadata, to share in their metadata, will allow others to build registries based on that data and connect collections and repositories in ways that we can't imagine today. Ideally, the next phase of this is to start to share more than just statements. Imagine if a user could see the data used to make a determination. Imagine if they could see that you've determined this thing to be in the public domain and you did that based on the publication status and publication date. That would increase the confidence in the statement and help highlight facts relevant to the users making their own copyright decisions. Okay, so the future of rights metadata. So in the 5 years we've been using this system, we've made some mistakes. The way that we've used digital assets has changed at NYPL. That means some of the original use cases that we had in mind that we evaluate on every item, we weren't making use of. So for example, we thought we'd be sharing more content with websites like Flickr and other kind of third-party sites that we push content to. As it turns out, we've invested in our APIs to allow others to more easily access the data and pull the content from our collections instead of NYPL pushing. We've also had to change some of the standards that we used to evaluate those items. And that means that we've had to make some changes in the system itself. The second lesson we learned is that something that you're all familiar with, when we're dealing with audio and moving image material, the level of complexity is exponentially more difficult. We're moving towards building out our capacity to account for all of the different layers of rights present in audio and moving image material, but that means that being able to identify all of the relevant layers of rights associated rights holders in these items. Because the overwhelming majority of audio and moving image material in our collections are in copyright, we've also needed to fine-tune how we serve that material and how we draw distinctions between different ways of serving that material. To highlight just a simple version of this complexity, a music sound recording will likely have at least 2 layers of rights. There'll be an underlying composition, and there'll be a copyright associated with that, and there'll also be a copyright in the performance, in the sound recording itself of the music. Each may be held by a different rights holder or different rights holders, and it becomes more complex when we get away from 2-dimensional materials. The third lesson is that we need to tap into unique identifiers. And this is especially true for us when we're talking about people. So if I want to build a database that tracks all of my contacts and all of the contracts we have with particular people across our collections, I need a standard way to identify that person. Luckily, my colleagues on the descriptive metadata side have worked on that for a long time, and we have unique identifiers for people. But the rights part of our system is just starting to use those identifiers, which means we've built up a lot of technical debt and administrative debt into that collection, into that administration of people, and we have some work to do to clean that up. Although much of this rights metadata is hidden from view today, it's easy to imagine a world where we share more and more of our data. It'll help eliminate redundant efforts, but we need unique identifiers to be able to describe and talk to each other about individual works. We've made it easier, having rights metadata will make it easier for rights holders to work with institutions to identify those works and claim those works to make sure they're not orphaned. And it helps us to rebuild a copyright registry that we kind of gave up as a nation in 1976 when we passed copyright law that didn't require registration and deposit. So we've also learned that our data model is starting to creak. This hierarchical structure has served us very well for many years. But the triples and relational data that we talked about in the first session are becoming more and more useful and more important to us. That means we're going to have to rethink about how rights metadata can cascade down and across collections, and we've got a lot of work to do on that. The last lesson we learned is that automation has a place in rights metadata. Right now, almost all of the data is done by hand. Eventually, we would like to be able to rely on the data itself to create determinations and set determinations that could be automated, hopefully in the future, so that me and my team don't look like this. Unfortunately, we've got very helpful tools for determining the copyright status of items, but those tools are only as good as the facts we have on hand. Unfortunately, we're often missing important information that would help get us to a high confidence determination. So in situations where we have good factual data, it'd be great if we could automate some of that decision making. Finally, the information we gather and record on our digital assets may appear to be intense, but for us, that's the appropriate level of intensity. We care a lot about protecting both the library and our rights holders, those who create content and those who use content. So we have a repository that has to deal with a variety of these issues. We also have huge numbers. We've got to deal with a variety of rights issues across collections and across items, and therefore we needed an intense kind of rights database. We've learned that we need this level of data to make informed decisions about our assets, and we've learned that using this data and having this data will enable our successors to understand why we made certain decisions. By taking the data out of the generic free text field, we've been able to use that data to prioritize items for review and understand the composition of our database. In short, we think rights metadata is a great thing to have, especially in the cultural heritage sector, and we look forward to working with rights holders and getting more access to rights holder databases that are held by industry so that we can all start to communicate across those industries. So with that, I'm happy to let's answer some questions, but I hope that kind of sparks some conversations so we can learn from each other. Part of the great part about this forum, about this symposium, is that I get to talk to people who I don't normally talk with, and you get to talk with a library copyright nerd that you might not be able to normally talk with. So I look forward to your questions.
Hi. Whoa. Um, I, yeah, sure. I'm John Passmore. I work at New York Public Radio. My question is, how often are the rights unknown or too hard to know? Yep. And then if they are unknown, what do you do?
Yeah, so about a third of our repository today is marked with a code that says undetermined, need further information. So that's about a third of our repository. In those situations, it comes down to our risk profile. So we can start to dissect that unknown category in ways that we think are appropriate for the library. So for example, I have a collection of 10,000 photos taken during the World's Fair, the 1939 to 1940 World's Fair in the collection. It's unclear what the copyright status is because at that time, if they were published, they may be in copyright, they may not be. It's difficult to determine without more information. So that collection is in the repository as undetermined, need further information. However, because we know that there's likely not a rights holder out there, the World's Fair Corporation doesn't exist, and in fact they wrapped up in our building. They spun down the corporation in our building. We know that there's likely not anyone out there who's going to object to our uses. So in that situation, we've been able to make those photos available and take the risk on, even though it's an undetermined item. But that's not always the case. We've got, it's not always clear what the copyright status is of items, and if it's outside the risk profile, we don't make uses of it.
Thanks, Greg. Andrea Callis. So obviously your users are a key stakeholder. So the more you can publish online, the more they can get access to them. That's a key driver for it. I just wondered whether or not this also had an impact on other key stakeholders like donors to the library or funders of digitization projects and how that.
Yeah, so first on the donors. So donors of collection items, they have all been very excited about this rights database because it means that we can account and track their wishes. So some donors want certain collections segregated and closed off for a certain amount of time for privacy issues or whatever, and having a database like this and showing them that database encourages or it makes them more confident that we'll actually comply with those terms. For our funders, being able to track copyright status is becoming essential. In many cases, the agreements that we sign with funders require us to release items available, release all items in the public domain without any restrictions. So being able to have a database like this that tracks those items is essential to those funder agreements.
I have a question, Chris Lisinek. So I'm curious, up front you noted some lawsuits around commercial works, and I think largely, well, no, there was some, it's not all print, was it? The UCLA was right, DVDs, I think, yeah. But I'm curious, are there suits or case law anywhere around unpublished works?
There are. So there are a few lawsuits, and there's one brewing right now about the use of an unpublished item that was ultimately used commercially. And through a quirk of copyright law, the fair use provision in copyright law kind of preferences published works. It says that if the work is published, we're going to allow a little bit more room for fair uses. But if it's not published, we want to protect the rights of rights holders to make that first publication, and therefore we're going to be a little bit more narrow in our application of fair use. So in those situations, we have encountered lawsuits like that where the fair use claim is narrowed and it is on unpublished work. Although I will tell you, for archives and libraries, it's very rare. In fact, the three that I put up on the slide are actually some of the only recent three that have happened. There are a few others that are brewing, but not totally full-fledged, drawn-out lawsuits yet. So it's a safe environment, but it's still there's some risk still there.
Hi, thanks. Very interesting. I'm Tom de Smet from Netherlands Sound Institution Sound and Vision. Well, first of all, we're very envious in Europe about your fair use exception. There's no such thing. So we can't really do much with our material, especially in audiovisual material. One of your main tasks is to expand access to the collection of the library. When it comes to audiovisual materials, which are, as you said, much more complicated, have you been looking into extended collective licensing, or is the fair use exception enough or sufficient for the ambitions of the library?
Yeah, so we've been relying on fair use, and libraries are on record as opposing extended collective licensing. And just for everyone in the room, extended collective licensing is a model of licensing where a group or entity can represent or license the works of everyone in the community, and even those beyond the community. So for example, the Authors Guild very much wants an extended collective licensing schema to happen so that they can administer rights for authors regardless of whether they're members or not. Institutions like mine would then pay into those licensing regimes and get kind of an insurance policy to some extent to be able to use those assets without getting sued. So in the US, libraries are pretty cohesive and in an agreement that we don't want extended collective licensing. We think that's a bad model for the US, and instead we're relying on fair use for much of the work. Yeah, our Europeana colleagues on the Rights Statements project were always very envious of fair use, and that was part of the frustration and part of the hard part about coming up with statements that apply globally. Where some regimes have fair use and others don't, it's hard to have rights statements that can bridge those gaps.
Hey Greg, it's Diane. Are you using a ontology or using Pronto or one of the rights management ontologies?
We are not. So we've looked into those, and we just haven't found one that we think can do the work that this can do yet.
Are you going to publish your own then?
That's what the next step for us. Yeah. So it's been on my goal list for 3 years, but we're going to get there. We've got to get there because so many more institutions are asking us for this kind of system.
Hi, Greg. It's Rena Pantalone from Columbia.
The other copyright nerd.
The other copyright nerd. I have a comment and then a question. And the comment really is I'd love to have both you and Diane on the stage at the same time having a conversation. Because one question, it's just kind of almost obvious, is since you've released all those public domain images, what's the uptick? What are you getting as feedback from your patrons and your users?
So the number one feedback, they're all very thankful, but really the best feedback that we're getting are fixes to the metadata. We actually have patrons contacting us and saying, the photo that you have has the wrong person. You've identified this person, you misspelled their name, please fix their name. And those metadata fixes aren't because it's public domain. Those metadata fixes are coming because the collection has been highlighted and it's been valuable to lots of users. So they're using it. They're actually looking through these things and finding errors. And those metadata errors, those metadata corrections are happening now. And I think that we're about to publish some numbers about how many errors we fixed by using the crowd, by relying on crowds.
Quickly, my second question is about DPLA and the rights statements. Could you flesh out a little more for everyone in the room where DPLA and Europeana are at in even determining how you name something public domain?
Well, so the Rights Statements project that was just released has public domain statements. So they're just starting. DPLA at least is just starting to implement these statements. Europeana is ahead of us on this. They've been doing this for a number of years, and they've been able to label things public domain by using a Creative Commons public domain mark for a while. Europeana is now going to switch over to rightstatements.org as well as DPLA. It's going to take a few years for the uptake on that. I think that we're at least 2 or 3 years from having 60 to 70% uptake on that. And part of the concern there is that institutions like mine and institutions like yours can deal with these kinds of in-depth rights analysis. But the little historical society who's got a film or something can't deal with it at the level that we can deal with it. So it's going to involve some education. And I think that's going to be the next critical component of this.
Christy King, I'm a consultant. I'm curious why you decided to build your own database system. Would you make that same decision today? And what's your plan for development going forward? Just super high level. You don't have to explain code to me. It's okay.
I couldn't do it anyway. So would we build the same system today? So no, I think that it's pretty clear now that there are tools, Hydra tools out there that we would probably use instead of what we did. We still have a problem though, because the level of specificity that we want in our rights data is not available right now in the systems that we keep seeing. So the museum system is a dominant player in this field, and they just published a new version of their software that has a rights tab now, but it doesn't have all of the fields that we would want to see in it. We're also considering how we're going to work on relational data. As we move away from the hierarchical system that we have today, we're going to have to figure out how we're going to have rights metadata integrated into that system. And that may mean scrapping the metadata management system in favor of something else. We're not there yet.
So Rob Cardellano, Columbia, just to elaborate, Hydra is Project Hydra, and it's a community-based project to build an open source framework for software above, around, and surrounding repositories, and it's an international community working on this. Rights metadata collaboration is one that we're all tagging as a next major step forward. And it is, of course, dealing with linked data and ontologies. That's part of the nature of that system. So we'd love to have a broader community from the industry to work with that. So if anybody's interested, talk to any of us from the library community.
Yeah, I was at a panel at the USPTO, the United States Patent and Trademark Office, 2 years ago with industry stakeholders. I was the only one who was kind of representing the user side or the library side. But we were talking about rights metadata and unique identifiers. And it was amazing to talk to industry, and they all have databases of unique identifiers and rights information that's related to that data. But that data is all walled off, it's all closed. And there are good reasons in many industries to do that. They don't necessarily want to share that data. Maybe there's proprietary information in it, great. But what would be great is if we could start to open those walls up and start to share that data so that we don't all have to build databases and describe things in the same way among many different industries.
All right. Well, thank you, Greg.
Thank you.